Good evening to you all. So, thank you very much for your patience. I would like to welcome you all for the today's public lecture on invention, intellectual property, and patents. On behalf of Sectional Committee, ISL, and the committee, I would like to welcome you all again. And I want to express our gratitude to today's lecturer, Engineer Ananda Namal. He's a former Director General of NERD. So, before moving to the lecture, so I would like to invite Engineer SMP Sirivardhana to introduce Engineer Ananda Namal.
Thank you, Engineer Hemachandra, and Chairman of the Sectional Committee. So today's our presenter is Engineer D.D. Anand Namal. He is the former Director General of NERD Center. And young engineer Anand Namal joined the NERD Center in 1987 as a research engineer and rose through the rank to become Director General in 2011 after holding several research positions. During his time at the NERD Center, he published a number of research papers. He retired from the position of Director General of NERD Center of Sri Lanka in November 2022 after 11 years service as Director General of the NERD Center. He received his undergraduate degree in engineering from University of Peradeniya and his postgraduate degree in energy technology from University of Moratuwa. He is a chartered mechanical engineer and a member of the Institution of Engineers Sri Lanka. He is a member of the Sri Lanka Energy Managers Association, SLEMA, and has served as a member of the board of directors for several years. He also served as a past president of SLEMA. He also served as a member of the board of directors of the National Cleaner Product and the Sustainable Energy Authority of Sri Lanka. He is a corporate member and board member of the Sustainable Consumption and Production Forum of Sri Lanka. He is an accredited energy auditor and the country's first accredited energy auditor. He was a visiting lecturer at universities of Peradeniya and Moratuwa, as well as resource person for various training programs in the fields of energy management, and pollution control. He has extensive experience in the fields of energy management and environmental management. So now it is over to you, Engineer Anand Namal. We are willing to have a good, valuable presentation from you. Thank you.
Thank you, Srivardhana, for kind introduction, and thank you, Hemachandra, for inviting me for this public lecture. And let me open my presentation. Hope you all can see the slide.
Yes, we can see. Thank you.
Okay, good evening to all of you, and let me start the presentation. Yeah, and I will be starting with the introduction of the intellectual properties and the patents, and then go to the patent requirements and the patent validity, patent rights, and lastly, patent commercialization. Actually, I selected these topics because nowadays we all talk about the new invention, and we all know that the new invention is engine for the development of any country. And as engineers, you all can contribute to the new invention, and maybe you may come across several new creations in when you are working in industries. But most of the time, our engineers are not much aware about these patents and how to protect their intellectual properties. So I think this topic may be something different from our engineering topics, but maybe it is interested to you all. The expected outcome of this presentation at the end of the day, you may be aware of the type of intellectual property and also aware of the importance of the patents and requirement of the patents and the patent rights, and aware of the patent laws and regulation and how to file a patent. Yes. As introduction, so patent is an intellectual property, right, granted by the state for an invention. Right. Here there are three keywords. One is the intellectual property, other one is the state, other one is the invention. Yeah. Then the state, that is the country. It is granted on behalf of the Sri Lanka. It is granted by the National Intellectual Property Office of Sri Lanka, NIPO, at the Samagam Madura. Right. So when we say the state, then the patents can be granted only for that country, because one country can't grant the patents to another country, right? Then what is intellectual property? So we know that what is property in our conventional properties, maybe lands or the vehicles, buildings. Those are some tangible properties, right? But intellectual property is an intangible property, but its value is more than those tangible properties. Sometimes the value of the intellectual property is very huge, right? As these tangible properties, intellectual property has some boundaries, and so, yes, there are various kinds of intellectual properties. Actually, there are 7 intellectual properties. Patent is the one of them, right? Others are this copyright, trademarks, industrial designs, ICT, geographical indicators, and databases, proprietary databases. Those are basically the knowledge base things. But today's focus is on the patents. I am not going to discuss other intellectual properties in today, because this patent is very much related to our work. Other keywords in the patent is, one is the intellectual property, other one is the invention. Actually, invention is the creation of a new product or a process that has not been known to the public, or not being existent in the nature. That is the two things important in the invention. One is the not being known to the public, or the not being existent in the nature. That's the general definition of the invention. There may be some more definition, but in terms of the patents, in Sri Lanka, our patents is governed by this IP Act, Intellectual Property Act number 36 of 2003. In that act, it is defined for the patents. The invention is defined as, invention means an idea of an inventor which permits in practice the solution to a specific problem in the field of technology. Yeah, this is for the this definition is for the to grant the patent for an invention. That is the invention. Then the very important words are that is the solution to a specific problem in the field of technology. So your invention should be a solution to a technical field in the field of technology for a problems. What is the purpose of granting patent? Why do we grant the patent for an invention? Actually, if this patent process is not there, there won't be these facilities that we enjoy today, because the inventors spend a lot of time and the money or the resources to invent something, invent a new thing, right? So once you invented it, if others can produce it and market, then the inventors are discouraging and they may not be doing it again, right? Therefore, this patent has made the ability to develop these technologies today. Yeah, therefore, it is very important to grant it a patent. Then the one purpose of the grant in the patent is to protect the IP rights or the intellectual property rights of the inventor. So once you get the patent for your invention, then you are the owner of that technology or that invention. Then others can't produce or the sales or the others can't do anything without your permission. Once you get the patent for that your invention. If they want to produce or the sales or do something with your invention, then they have to get the permission from you or the inventor. That is the one purpose of granting the patent. Then the inventor he has some economic value of his invention. But the most important thing is that to reveal the knowledge to the public for the betterment of the society. Because everything is belong to the society, right? If you invent something and if you do not reveal it to the society, then there is no meaning of that invention. There is no use of that invention. So this main purpose of granting patent is to reveal that knowledge to the public for the betterment of the society. The patent has some period for the validity, right? Specific period, because once you get the patent, you can't hold it forever. Basically, in the most of the countries, the validity period is around about 20 years. In Sri Lanka also, validity is for the 20 years. Once you get the patent, so after 20 years, it becomes a public property. So anyone in the world can use it or they can do any business with that patents after the 20 years of the period passed. And also, the patent is valid only to the territory of a country in which country you get the patents, right? If you get the patent for Sri Lanka for your invention, that validity is only in Sri Lanka, right? So anybody in Sri Lanka, they can't produce or can't do any business with your invention, but anyone in the other countries, they can do anything. Because if you want to protect your patent in other countries, then you have to file the patents in each country. There's nothing called an international patent. We have heard that some people say that they are having some international patents, but there's nothing called international patents. If you want to protect your invention in other countries, then you have to file your invention in all the countries. But it is not basically practical or economical to file the patents in every country. So what you do is you protect your invention in the countries where there's a potential for that particular invention. So if you have an invention and if you want to protect it in USA, then you have to file the patent in the USA. Then anyone in the USA can't produce it, but people in other countries can produce it, and use it. They can export to other countries, except the country where your patent is granted. And this is the validity of the patents. Therefore, the patent process is very expensive if you want to protect your patent in a lot of countries. Therefore, normally what people does is they they obtain the patents for the countries where their invention has some potential for use of yours, right? The public can't copy your invention during the validity period within the state. That means they can't produce, they can't sell or store or import without the permission from the patent owner, right? So if you obtain the patent in Sri Lanka, then people in India, they can produce it, because when you obtain the patent, you completely reveal your invention. So anybody can assess it. Then anybody can make it. Technically, anybody can make it, but this patents protect the making it from the country where you get the patents. But the persons in India can produce it, but they can't import into Sri Lanka. if your patent is in Sri Lanka, right? Then the public can use the knowledge to make improvement, even during the validity period. Your patents can use by the public for their improvement or research purposes, but they can't use it for the commercial purposes. The important is that, can we obtain the patent for every invention? Because people do a lot of invention, but you can't get the patent for every invention. There are some limitations, right? And the intellectual property has defined the subject matters negatively, which you can get the patents, right? The legislation in that particular country, they define it. What are the subject matters you can't get the patent? Basically, those things are it is common in the many countries. So your invention should be in the patentable subject matter if you want to get the patent for your invention. These subject matters are the subject matters which you can't get the patents. So you can't get the patents for discoveries, but for the creation. You can get the patent for the creation, but you can't get the patent for the discovery. So you can't get patent for scientific theories, for the mathematical models or the methods. You can't get the patent for the plants and animals, microorganism, other than transgenic microorganism, or you can't get the patent for the schemes, rules, or methods for doing business, performing purely mental less, or the playing games. Or you can't get the patent for the method for treatment of human or animal body by surgery or therapy and diagnostic methods practiced on the human or animal body. And you can't get the patent for an invention which is useful in the utilization of special nuclear material or atomic energy in an atomic weapon. Other than these subject matters, you can apply for the patents. Other requirements or the patentability requirements are that if you want to get the patent for your invention, it should be new, right? That is, novelty is the one condition. Novelty means it has to be first in the world. When nobody in the world has done this before, right? It should be new, and also it should involve an inventive steps. And that means it should be not obvious to a person having ordinary skill in the art. You can't get the patent for some things which is obvious to a person having the ordinary skill in the art, and it should be industrially applicable. Those are the treaties that you have to fulfill to get the patent for your invention. It should be new, that is the first in the world. It should involve an inventive step, that's not obvious, and it should be industrial applicable. Oh, that means it can be made or used in any kind of industry. You can't get a patent for just ideas, right? It should be industrial. It should be made and used in any kind of the industry, because sometimes people try to get the patents for just for the ideas, but you can't get it. Number one condition, that is novelty or the new. This new novelty is ascertained by searching the previous work. Once you file up your patents, then the body who grant you the patents, they search in the your this patentable subject, what is known as the prior art, with respect to revelation, right? If it is not found in the prior art, then it is considered as a novel invention. As per the IP Act of Sri Lanka, an invention is new if it is not anticipated by prior art. What does it mean, prior art? Prior art shall consider everything is close to the public. It may be a written things or the publication or oral disclosure, you saw any other way, or in the, maybe in the newspapers or maybe in the exhibition, if you reveal it before filing your patent application, then it will be disqualified for to obtain a patent. Therefore, if you have one invention and if you are willing to get a patent, you should not be disclose it before making the patent application by any means, right? But there is some flexibility for the applicant. If the applicant is disclosed it within a year, then it is neglected, right? You can apply for the patent if your disclosure is within a year for the some maybe maybe for some commercialization discussions or the some paper presentations. But if it is done within the year, you can apply for the patents. But that has to be done by the applicant itself for his predecessor, right? Other than that, it is not allowed to disclose your invention. If you disclose it, then that novelty criteria is not there, then you can't get the patent for your invention. Therefore, anyway, it is very important. It is better to not to disclose your invention prior to filing your patent application. Then there is a chance for the rejecting your application if it is disclosed in public. This everything in the public domain means already patented invention or research literature, newspaper publication, exhibition, or any other public disclosure. Even it could be even a leaking out of information by a research mate or the company employee. Yes. To grant the patent, it should be a patentable subject matter, number one, right? Number two, it should be a new involving inventive step and industrial applicable. And also, you have to sufficiently disclose it. If you do not disclose it completely, they will not grant you the patent, because one of the most important purpose of the granting purpose is to reveal the knowledge to the society, right? So you have to disclose it sufficiently so that a person having ordinary skill of that can produce the item with the information given. So the making application for the patent means then you reveal your invention to the whole world completely. So you can make the patent application, that's a standard form in the NIPO. Through that, you can make the application to the Director General of the NIPO. And until you making the application, care should be taken not to make any public disclosure. With that application, you have to submit the request to the grant patent and description of the patents with claims, drawings, and abstract, and the date and number for it. If you have make any application in any foreign country, that also you have to mention in your application. Once you made the application in the respective country, then you will be assigned what is called a priority date. Then this priority date is very important. Before the priority date, your invention should not be disclosed, so it should be new. Once a priority date is assigned, then you can do whatever you want with your invention without any risk. You can reveal your invention without any risk. Once a priority date is assigned for you, then you can even do the start the production and do the commercial business with your invention, even without the patent. But once a priority date is given, then you can mention as the patent is pending. Then nobody can get the patent for your invention, and there is no any risk of rejecting your invention if you do this commercialization or the manufacture of the item after the issuing the priority date. Yeah, because once you make the application to the NIPO, it will take some time, 3 to 4 years to obtain to get the patents. But it doesn't matter for your other future works. You can even give the license to your invention by pending patent, because no one can get the patents for that particular invention once a priority date is assigned. Now, if you want to make application to some other country, or if you want to protect your invention in some other countries, then you will have to make applications each country separately. If you want to protect your invention, let's say in 5 countries, then you have to make application in all these 5 countries separately. Then, once you have applied patent in one country, maybe in the local, if you apply for the local patent in Sri Lanka, then how can we apply for the other countries? Because once you applied it, it is revealed. Then it is not new. When they search in the after you apply in the local patent, and after that, if you apply for some other countries, when they search in the prior searching, then it will say as that there is this knowledge is there, right? Then there will be an issue, you think, but to avoid that issue, there are some international accepted mechanisms available, right? The Paris Convention and the Patent Cooperation Treaty, which is commonly known as PCT process, are the such mechanisms which are mostly used in application in some other countries, right? In this Paris Convention or the PCT process, then you can transfer your priority date to other countries. This Paris Convention, almost all the countries are signatories for the Paris Convention. Then all the signatories can use this convention for patent application. So with this Paris Convention, an inventor can make a foreign application within 1 year from the original filing date. Right? If you make the local application, let's say the 31st August, then until the 31st August 2022, then until the 31st August 2023, you can file a patent in some other countries with your priority date. Then those countries will consider your priority date as the original date, and they search whether it is known to the public before that priority date. But within 1 year, you have to make the application in other countries. If you fail to make your application within 1 year, then you can't get you can't protect your invention in many other countries than you have already protected. Yeah. Other application procedure is the PCT. This is the most commonly used treaty for the application of your foreign application for your invention. This PCT procedure is administered by the WIPO, that is World Intellectual Property Organization. This is also, all the countries are basically signatories of this WIPO and the PCT. So if one make a PCT application with WIPO, PC can make local application in any country within 30 months from the original date. In the Paris Convention, you have only 12 months, but if you got the PCT application, then you can make your application in other countries within 30 months, right? Then you have enough time to think and select the countries where you want to make your patent application. And also you can get the combined effect of the PC and the PCT. That means you can make a local application in one country and make a PCT application within 1 year as per the Paris Convention. Then you can make the local application in any other country within 30 months from the original date of application. Right? These two conventions help you to make application for your invention in other countries, but keep in mind that if you want to protect in other countries, you have to make the application separately for each and every country, which is very expensive process. Why do want to have a patent? What are the rights of the patents? Right? Normally, the patent right to the patent is for the inventor. The patent is belong to the inventor. When more people have jointly make an invention, right to the patent shall belong to them jointly. If the one team work together and make an invention, then the right to the patent goes to the team. If two or more persons have made the same invention independent of each other, the person whose application has the earliest filing date shall have the right to the patent. Because sometimes two people can work independently in two countries, but the right to the patent is for the person who filed the application, earliest filing application, who made the earliest filing application. Yes. As per our act, if you are working for some organization, and if you do some invention as the result of your job contract, then the right to the patent is for the employer, not the employee. If there is no any other agreement between employer and employee, right? If you have some agreement between employee and employee, that agreement will be effective. Otherwise, the right to the patent is for the employer. For example, if you are teaching in the university, and if you do a research and get the patents, then the patents is belong to the university, not to the researcher. But if the university and the researcher have some agreement about the patent rights, then that agreement will be effective. But even the right to the patent is for the employer. If the benefit of the patent is very much higher than what we have seen at the initial research, if it is very much higher than the economical benefit, then you can claim for that patents. The remuneration you can share the remuneration as decided by your employer, and you as an agreement you can decide. If the employee is not willing to give you some benefits, then you can go to the court, and the court will decide that how is that benefit is shared by the employer and employee, if the benefit is much more higher than what we have foreseen in the initial stage. But basically it is belong to the employer. Similarly, if you are work for some contractor, then the patent right is for the contractor, not for the you. But if the benefit is much more higher than as expected at the beginning, then you can get an economic share from that patent with the agreement of the contractor. If the contractor is not agree with that, then you can go to the court and get the court order, and based on that you can get the benefit from the patent or your invention. This right given in this act, employers can't deny on those things. They have to agree with this right. And also, though it is belong to the employer, your name has to be in the patent document as the inventor. Then what are the right of owner of the patent? So owner of the patent, as if the patent is belong to you, then you can exploit the patent, the invention, or you can assign your patent to some third party, or you can conclude some contract, right? No person should do any of that referred to the above without the consent of the owner of the patent. Once you get the patent, nobody can do it, or nobody can use it to produce or do a business or sales or produce an store or the export, that things without permission of you. And provided these things, right? Subject to the provision of these things, you can do the commercialization of your patent. Those things are extended only to have done industrial or commercial purpose. If someone is use your patent for some research purposes, then it is allowed, right? This right is not extended to presence of use of product on foreign vessel, aircraft, spacecraft, or the land vehicle which temporarily or accidentally enter to the border, air, space, or territory of that particular country. And not extended to that in respect of articles which have been put in the market by owner of the patent or by a manufacturer under the license. Because as per this right, no one can use your patents. But if the items are manufactured by you or your licensees, then that is allowed. How can you commercialize your patents? There are basically three ways. One is you make yourselves. You can manufacture your invention by yourselves, or maybe with the with someone with the collaborative agreements, or you can assign an investor, or you can sell your idea or your patents for a lump sum amount, and then he can do the manufacturing and business, or you can use licenses to maybe one person or the one entity or the several entities to do the business with your patent. There are three kinds of licensing procedures. One is the sole license as well as the exclusive licenses or the non-exclusive licenses. Exclusive licenses with the some entry with exclusive right in certain aspect, or you can do the licensing without any restriction. So what will happen if the inventor does not commercialize the patent? If you invent something, if you obtain the patent, then nobody can produce it. If you don't produce it, what will happen? Then that knowledge will become no use, no? But then basically the knowledge is belong to society. It has to be used by the society. Therefore, if the inventor does not commercialize the patent, then as per the law, Director General can issue a license for the exploitation of any person, body of the person or the government department or body on request. If you are not giving it, the DG can license it, but the license fees or the economic benefit they can give to you, right? Limited scope, duration, purpose as per the license. You know, this clause is there because sometimes some people obtain the patents and they keep it as a secret, or sometimes people buy the patents and they do not produce it and they keep it. Then it is unfair to the society. Then DG has power to issue the license for your patents with the terms and conditions determined by the DG. Then the patent validity is, as I explained earlier, it is only for, in Sri Lanka, it is only for 20 years from the filing date. And most of the countries, it is 20 years. And though it is valid for the 20 years, it expires after the first year. If you want to keep this patent, then you will have to pay the annual fee as prescribed in the depot by the depot, right? You are given the 6-month grace period allowed to renew the patent. If you are not renewed your patent annually, then your validity lapse. Then once your patent validity is not there, anybody can make it or produce it or sell it. Therefore, it is very important to keep your patent alive. In the legal status of Sri Lanka, that is patent law that is covered by the Intellectual Property Act number 36 of 2003, and the regulation made under the provision of the Act. Other thing is that if somebody infringe your patents, then you will have to go to the court and protect your patent rights. The government or police will not involve with that. Basically, then you have to go to the court and get your rights. That is the legal status of the patent in Sri Lanka and in the countries as well. Yeah. It becomes the structure of the patent documents. When you are going to file a patent, then it is very important to prepare this patent document clearly. Basically, it consists of the title, abstract, and the description. That is the background of the invention and the presentation of the technology and discourse of the invention, and the claims. That is the real invention you made in that particular invention. Even you have submitted drawings and sketches with your patent application. The title has to be brief to describe the invention, be complete, should not be misleading. The main purpose of the title is to enable effective search, because by title the examiners search the prior. Abstract is basically for the base discussion of your invention. That is the main purpose is to enable to effective search, right? The description basically comprises of the background. That is what is the requirement of your invention and what is the present state and the technology of the your invention, and what are the problems you are addressing, etc. Then the disclose is the what is your invention. You have to completely describe your invention. That is the most difficult part in this patent application, this writing the claim. That's the most significant part of the patent. It should necessarily contain the what is invented. It has to be completely disclosive. Then the body of the claim described the invention clearly and completely. Yeah, that's the basic coverage that I wanted to talk today. So we can have a discussion.
Thank you very much, Engineer Namal. Thank you very much for the wonderful presentation. It was very concise, and I hope even audience, they understand, they learn a lot out of your presentation. So without taking time, I would like to open for question. So in the audience, if you have any question, you can raise your hand, then I will allow you to ask the question. So this is very interesting presentation, I think very useful for our engineers. Until someone asks his question, so let me ask one question from Engineer Namal. So assume that there is an invention on the medicine, which is very much needed for the humanity. And then because the gentleman who did the invention, when he's going to commercialize it, so his term is not reasonable. So that badly affect for the humanity again. So what is the way of controlling, managing that kind of situation? I don't know whether I asked right questions. I think.
I didn't get the question clearly. What's the really?
Assume that someone make an invention on medicine, right?
Right.
Medicine, which is very much needed for the humanity, human beings. So then when he's going to commercialize it, when he's going to commercialize, his terms is very much unreasonable. So it is not good for the public or human, I mean, the humanity to make such a payment or something. So is there how to control such situation?
You mean that someone has to get the patent for some kind of the medicine, and he demand some of money to give that patent to commercialize, right?
That is not feasible for public to pay for that medicine. That is badly affect. That is my question. Yeah, correct.
Yeah, that's the question. No, then actually this patent authority has power to mediate it for the discussion, and they can decide it. If it is an unreasonable price, right? Then that's mean, because that means that he's not giving license to anyone for a reasonable price. No, then that patent is not used. Then the patent authority has power to decide what is the reasonable fee for that invention as per the our IP Act.
Right. Engineer Samudaya Nanayakar. Engineer Samudaya, it is for your, you can ask your question. Engineer Samudaya, you can ask your question.
Maybe he's mute his mic.
He can unmute his mic. Engineer, okay, Engineer Samudaya,
Okay,
go ahead.
okay. Good evening. Thank you very much, because previously I couldn't unmute because maybe assistant admin locked that option. Okay, thank you very much, Namal, that wonderful presentation. I have two questions. One thing,
Right.
I don't know, you covered that one in the first 5 minutes because I came 5 minutes late. So how much is it cost for the patent application process?
Yeah, actually, in Sri Lanka, the local price, the new price, actually, I do not have an idea the latest price, but
Okay.
2 years back, it is in the range of 10,000 to 15,000 in that range in Sri Lanka. But the foreign VCD application, it is in the closer to the 1 million those days, but I think today definitely much higher than that.
With the new currency rate. Okay, second question, you have mentioned about the application only for the particular country, that there is no international patent or something. So that means if somebody took a patent in Sri Lanka, same
Yeah.
product, another person can take the same thing in the India or other country if there is no patent taken by the same inventor, isn't it?
No, once you get the patent in Sri Lanka,
Yeah.
nobody in the world can get the patent for that particular one, because the knowledge is revealed now. Then, right?
Okay,
But
you have mentioned about it for the first time in the world, isn't it?
yeah, but
Yeah.
the people in other countries can produce it, and they can do the commercial businesses with your invention, because it is not protected in those countries.
Okay, that means that they can produce a product, but they can't obtain the patent.
To
Yeah.
obtain the patent, it has to be first in the world.
Okay, that person can export the product into particular country as well. That
No,
means
no,
that,
he can't, because if you get the patent in Sri Lanka, then the person in India can produce it in India, and he can export to all the other countries except Sri Lanka.
okay, thank you very much. That clearance. Okay, I have doubt about those kind of things. And thank you very much for the organizing this wonderful lecture. Thank you.
Thank you, Engineer Samudaya. Is there any other questions? I think it's a wonderful presentation. You might have a lot of questions out of this presentation.
Yeah, this is a small question. I am Fernando.
Yeah, please
Hello.
go ahead. Yeah.
Yeah, you hear me? Actually, Namal, my question, there are a lot of engineering products in the world, in the market area. If somebody makes the maybe similar product, not 100% same with that one, maybe material, maybe some principle, maybe some small deviations in my manufacturing, right? For that thing, can we make some payment? Maybe some Indian, maybe Indian some machineries like that. We go through the internet and we learn and study something, and we improve something, and we make a product. In that case, can we make a patent?
This is the case. If something is produced in, sorry?
Yeah, actually, it is not the identical product, but there are some deviations from the available existing product.
Yes. Yeah. Two things. Any patents, for any patents, you can do the improvement.
For the improvement.
Yeah, for any patents, you can do the improvements, and you can patents for that particular improvement. You can prove it, satisfy that patentability criteria.
For the particular product, we cannot apply only anything for the improvements which is done in the product.
Yeah, and if that is not patented in the work, you can produce it. Other thing.
Right.
For example, if you have a good, let's say in UK, and if that particular inventor has no in Sri Lanka, you can copy it and you can.
Engineer Namal, your voice is repeating again. Your voice
Yeah,
is repeating, some echo is coming.
Some barrier, yeah.
So, yeah, I also feel that voice. Yeah, I don't know why.
Uh,
Yeah.
No,
Mr. Amal, I understood the thing. Understood. Thank you very much.
any other questions? I think it seems two instruments are working, like two microphones working. That's why echo is coming. Two computers, phone and computer together. I don't know. So
yeah, your one is okay.
yeah,
No, it's okay. No?
yeah. From your side, do you have two equipments? Are you using two equipments like phone and computer both? So that might be the no, ne?
Yeah, I have only the computer now.
Okay. And there's a question in the chat box regarding the time. I think how long will it take when one make the patent application? That is a question. I also have another question, Engineer Namal. This is regarding one of the previous news. I can remember the Apple go to whatever the authority and ask damages from Samsung regarding their design on their phone, saying that they Samsung copied part of the Apple phone. I don't know, it's maybe the shape of the Apple phone or something. So does that mean Apple has gone and get the patent from each and every country? Is that the case? These two questions.
Yeah.
Thank you.
Yeah, question number one. In Sri Lanka, it will take nowadays, it takes about 4 to 5 years to get the patents once you file it. But don't worry, as soon as you file it, it's protected. You can use it. But to obtain the patent document, it will take about 4 to 5 years now. For your question, second question, yes, if the patents protected in all the countries or the countries where the patent is protected, only them they can't produce it. Otherwise, you can produce it. For this Apple and the Samsung one, if the Samsung is producing it is the Korea, then Apple has to protect it in Korea. Or if the Samsung is copying it in the Korea.
It is only in one country, ne? So they have to, okay.
Yeah, maybe they normally what they do is they take the patents in the countries where where the market potential is there.
Okay.
Right. So, for example, if let's say if the Apple is not covered in Sri Lanka, then we can produce it here.
Okay.
But we can't export into the countries where the Apple has covered its rights, the countries.
Yeah, Engineer Samudaya, go ahead, please. Yeah, there's another question from you.
Yeah, Engineer Namal, based on that discussion, other than patent, what are the other commercial protection available for that type of things, like Apple or something like that?
Yes, for the technically, actually, there are, as I told you, that there are 7 kind of the IPs, but for the product related things is one is the patent is the main thing. Other one is the trade secret, right?
Okay.
They can keep their technology secretly, and such as this Coca-Cola, they have not then the patents, no, but the recipe is not leak out, so they keep at the trade secret. Right? If you don't, other thing, if you don't patent your invention and if it is very difficult to copy it, then it's okay. Because once you patented it, the technology is fully revealed, completely revealed. Right? If your technology is complex and no one can copy it from by looking at the device, or then you are protected. Because then you are not revealed your technology.
Okay, thank you.
Yeah, any other question from the audience? While asking question from audience, can I ask question from Engineer Namal again? The final phase, this commercialization, I feel is very important, right? So
Right.
what are the important aspects? How we can, even though we have patent, for an example, if I directly ask this question from you as a former DG of NERD, you got, according to my understanding, you have maybe so many patents, right? Am I correct?
Yeah.
But
Have
in the case of commercialization, what are the problem? What happened actually? It has not maybe not come to international market or the local market. So what are the important points that we have to look into when we are going to commercialize the thing?
To commercialize, in the commercialization, the patents number one is the patent should have some commercial value, right? Patent should have some commercial value. Then you can commercialize it to the biggest being the licensees or even the exclusive licensees. And the most important thing is the value of the patent or the technology. It has to be some good commercial value. Then you can easily commercialize it. And the one is the finding the good party for this commercialization or the partner for the commercialization. Everything is dependent on the actually this market value, I think.
Right. Thank you very much, Engineer Namal. So any other question from the audience? There's a question. Can you use, there's a question in the chat box. You can use industrial design protection as well?
Yeah.
Maybe statement. Yeah.
Industrial design is, that is not the patent, but industrial design is intellectual property. As I explained you in the beginning, there are seven kind of intellectual properties: patents, copyright, and industrial design is also one kind of the IP, right? So you can get the protection or the industrial protection from the certificate from the depot for your industrial design. That means industrial design means the shape of the product, right?
Okay.
Shape of the product, you can obtain the cover protection.
Right. There's another question. What is the meaning of licensing our product to another company?
The licensees, there are two kinds of licensees. Licensing means you give them the right to, you give some right to use your patents simply to somebody for a fee, right? For example, if you have the patent for some invention, you can use that right for the pollution that unit and maybe doing business in a certain part of the country or the whole the country or even the importation like that. You can use your rights or you can assign your rights to the somebody for a fee to the licensing. But that you can limit how extend you give your rights. In the exclusive license, or you can even sell your patent completely, that's the assigning, or you can keep the right with your patent right with you and give some rights of the patents to somebody to produce and do the business to the licenses. Maybe for one license or two licenses, even for the exclusive license or some single person.
Thank you very much for the answers. It seems there is no other questions from the audience. So with that, can I invite Engineer Tamira Vijayasuriya, our sectional committee secretary, to make a vote of thanks?
Okay, thank you, Engineer Hemachandra. Good evening, ladies and gentlemen. It's a great honor and privilege to propose this vote of thanks in this occasion. Firstly, I thank our speaker, Engineer Ananda Namal, for accepting our invitation and allocating time to conduct this public lecture. Thank you, Engineer Ananda Namal, for your time and the valuable presentation. Next, I would like to express my heartfelt thanks to the chairman of our sectional committee, Engineer M.G. Hemachandra, and the member, Engineer Sirivardhana, for their support in organizing this event. Then I would like to thank the staff of the ISL Publicity Division for facilitating this online platform by working behind the screen. At last, I thank for all the participants for your cooperation and making this event a success. Now, let's wind up this session. Once again, thank you all for your attention and cooperation. Good night. Good evening, everyone.
Thank you. Good evening. Good night.